Yes, sir. Sir, unmute, sir.
ಮ್ಯೂಟ್ ಮಾಡಿಬಿಡಿ ಹರಿಪ್ರಸಾದ್. ನಾಳೆ ಬಪ್ಪದು ನಮಗಿಂದು ಬರಲಿ, ಇಂದು ಬಪ್ಪದು ನಮಗೀಗಲೇ ಬರಲಿ, ಇದಕ್ಕಾರಂಜುವರು ಇದಕ್ಕಾರಕುವರು, ಜಾತಸ್ಯ ಮರಣ ದ್ರವಂ ಎಂಬುದಾಗಿ ಕೂಡಲ ಸಂಗಮ ದೇವರು ಬರೆದ ಹಣೆ ಬರವ ಹರಿಬ್ರಹ್ಮಾದಿಗಳಿಂದ ಲಲಿಸಲು ಸಾಧ್ಯವೇ? Good evening, members. Ravindra Koreer, Chairman of Bangalore Branch of SRC of ICI. Welcome all the viewers for the 61st JNANA DASOHA live webcast program from Bangalore Branch. We have with today's subject is intellectual property rights. We have with us uh, Advocate Hari Prasad MS with us. On behalf of all the viewers and on behalf of managing committee members of Bangalore Branch, I wholeheartedly welcome Advocate Hari Prasad MS to the today's session. Welcome you, sir.
Hello.
Dear members, today, as you know, the 61st, we have completed 60 webinars, and we Bangalore Branch trying to have diversified subjects apart from our regular topics, at least one or two in the month. As you know, every month we are conducting 10 webinars, at least one or two diversified subject means other than our regular practice, where chartered accounts can look after the topics and where it is connected, and the new youngsters start practicing our profession. Let they also come to know there is the area for practice for the new ventures, and how we can connect to the our other professionals like advocates and company secretaries. And because we all together have to be worked one balance sheet, if you start one balance sheet and signing up and concluding approving committee and going to the AGM, the professionals requirement in the different steps of the organization and is required. So in that thought, yes, we can have it in a session on intellectual property rights. So we requested our advocate friend Madhu, and then referred Mr. Hari Prasad. So today Advocate Hari Prasad is going to be, who is practicing in the same area, is going to enlighten all our members the where intellectual property rights and how, as you know, the intellectual property rights, IPRs, are the rights given to persons over the creation of their minds. They usually give the creator an exclusive right over the uh, use of his or her creation for a certain period of time. It is mainly the copyright related and industrial property, like that, the intellectual property rights, and how we can be registered. And that's overall, he will give the, today's speaker is going to enlighten, it is overview of the subject. And again, it is a vast subtopic. If you go to the World Trade Organization, where they, how they can rule and how the procedure and all, we can move to the, take some of the knowledge from the advocate Hari Prasad, and then definitely in upcoming days we can have more sessions on that topic based on the members' feedback. Members, I wholeheartedly, on behalf of managing committee member of Bangalore Branch, I wholeheartedly welcome all the delegates. Nearly about 500 delegates have registered for the today's session. I already near about 200 members have nearly joined the today's program. So I welcome all the viewers for the today's program. Members, you know that tomorrow we are having an not tomorrow, the next hour sessions will begin the next week on 23rd September. We had a session. We are having a session on RERA, overview of RERA and challenges, including formation of Residents Welfare Association.
Madam, there must be a network issue, madam.
Can I?
Yes, ma'am, we can hear you.
Yeah. Thank you, Chairman. To briefly introduce about our speaker of the day, Mr. Hari Prasad MS is an advocate by profession with more than 11 years of experience. Mr. Hari is also a trademark attorney and an associate member of Institute of Company Secretaries of India. Currently, he is co-heading the corporate practice at law chambers of Madhu and Rao, who is engaged in areas of providing taxation, corporate, FTP, and many other services. He was also co-heading the litigate practice with the law chambers of Mr. G. Shivda, senior advocate and former principal associate with leading multinational law firms in India. Hari is skilled in commercial litigation and corporate advisory services and in undertaking regulatory compliance.
Madam, it seems even your audio is also having an issue, ma'am.
Not able to hear?
No, ma'am. Now I'm able to.
No?
Yeah, now I'm
You're
able
able
to.
to hear now?
Yes, ma'am.
So we'll introduce from the first. Okay, sorry for the inconvenience. Am I audible now?
Yes, ma'am.
Okay. Sorry for the inconvenience, members. To briefly introduce Mr. Hari Prasad once again, he is an advocate by profession with more than 11 years of experience. Mr. Hari is also a trademark attorney and an associate member of Institute of Company Secretaries of India. Currently, he is co-heading the corporate practices at the Law Chamber of Madhu and Rao, who is engaged in areas of providing taxation, corporate FTP, DGFT, FAM, and many other matters. He is skilled in commercial litigation and corporate advisory services and is undertaking regulatory compliance. He has also advised both domestic and international clients on various matters. And among his other hobbies is also a trained swimmer, endurance long distance runner, and an avid trekker. He is also a BA LLB, qualified in the year 2009 May. The associate member of company secretaries in October 2010 and postgraduate diploma in intellectual property rights in 2012, master in business law in 2017. With this brief introduction, I welcome you for today's webinar. Sir.
Thank you,
Over
Divya,
to
for
the
the
speaker.
brief introduction. Thank you, Divya, for the brief introduction. Thank you, Bank chapter of ICAI and Mr. Ravindra Kore for giving me this opportunity. Today, we'll be discussing on intellectual property rights. I'll be giving an insight on the intellectual property rights because it's a very vast subject as such. So let me share the presentation. I have a presentation to be shared. Is the presentation visible, sir? Yes, okay. So when before we start with the presentation, this is the one question that you need to be in a position to answer after the webinar is done. Like all I asked was, can I patent my copyrighted trademark? As all these intellectual property rights in the same manner, or is it different? Is patent different from copyright and trademark? Now, the intellectual property rights in India have been broadly classified into these patents, trademarks, copyrights, geographical indications, trade secret, and designs. Now, these intellectual property rights have been governed by the following statutes. Now, the Patent Act is governed under the Patents Act 1970. The trademark is covered under the Trademarks Act 1999. Copyright is covered under Copyrights Act 1957. Designs are being covered under the Designs Act 2000. Geographical indications of goods, registration or protection indicates the geographical indications. Protection of plant varieties and farmers' right, protect the plant varieties like basmati, turmeric, neem, etc. So uh, I will be giving you an overview of what these intellectual property rights are there in India. How the intellectual property regime comes from the WTO through TRIPS agreement, trade-related aspect of intellectual property rights. Right? Now, what is IPR? What is intellectual property rights actually? What does the the main aspect that we need to understand in this webinar is intellectual property deals with patent, copyright, and trademark. Now, what does the Patent Act cover? The first slide when I showed whether I can patent my copyrighted trademark, that was one question that. Now, we need to understand that there are three different aspects in intellectual property rights. One aspect is a patent. Patent gives an exclusive right to the inventor to protect himself or have enjoy the invention that is made, right? Copyright is an aspect where literary, artistic, and sound work and other things like books, etc., they have been covered under the copyright. We'll get into it one by one, right? Trademarks Act. What does a trademark cover? A word, mark, or a logo, or a sound. These kinds of registration are given protection under the Trademarks Act, right? Now, what is a patent, right? What is a patent? Patent is an exclusive right granted for an invention, which is a product or a process that provides, in general, a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. Now, the inventor has to draft and patent specification. That is why the patents have been done by the engineers, or if it is a life science, somebody who is a science graduate will be, uh, registered as a patent agent. To be a patent agent, you need to write a patent agent exam, and then once you qualify as a patent agent exam, you can file patent application on behalf of the inventor. Now, how do I file a patent application? I file a patent application by drafting a patent specification, which is a technical thing. Now, what is a patent? What exclusive right is granted to a patent? It should be an invention. Now, when I say it is an invention, that means the invention should be novel, number one. It should have the utility and it should not be obvious, right? It should be a new product or a new process. It should have the utility for the invention that has been made, right? And then the invention should not be it should not be obvious. It should be non-obvious, right? That is what the Patents Act says, and the patent regime all over the world through the WTO is, right? The patent for a new invention, it covers a process or a product. It involves grant of patent by the country's specific patent office, right? If you want to get a patent invention to be registered, you need to file it in the US patent for specific protection of that patent in that country. If you want to get the protection, you will have to file it in the Indian patent registry office. Now, what is the incentive that I get? The incentive to get material award for marketable invention, one, you need to pass the none test, that is non-exclusive, utility, and non-obvious. The invention is patentable only if it is new, which is not already known to the public before the date of patent is applied for. Inventive step, not an obvious modification of what is known capable of industrial application, but it can be used in an industry. So for an invention to be protected, it should be non-exclusive. It's a new invention. It covers a process or a product, involves a grant of patent by a country's patent office if it is a new and a novel invention. Right? Now, what cannot be patented under the Patents Act? Now, it can't be a mere discovery of something or a scientific theory or a mathematical method. I found a new scientific theory, or I have discovered something, or there is a mathematical method for something. These can't be patented, and aesthetic creation can't be given a protection under the Patents Act. A scheme, rule, or a method for performing a mental act, playing of games, or doing business, or a computer program. So this computer program is again a debatable issue whether it can be granted as patent in India. In India, the computer programming is not given the patent right unless it is an embedded in a particular software, a software which is programmed to give an embedded technology like robotics and uh, CNC machine or anything uh, which gets embedded into a hardware, then it can be patented. But mere programming or the code which is written gets protected under the Copyright Act and not under the patent regime. A presentation of information, a procedure for surgical or therapeutical treatment or diagnosis to be practiced on humans or animals. None of these can be patented. In India, at least, these can't be patented. Now, one of the leading judgments in the US Supreme Court says anything under the sun can be patented under the US regime. But in India, there is a restriction on what can be patented, what are the things that can be patented under the Indian Patents Act. Now, patent specification becomes very important. I have given you two diagrams here. If you see the slides, one is a chair, the other one is a rocking chair. Now, while drafting is patent specification for registration with the registration, this thing, A and B invent related products. B is independently entitled to its own product. Now, if you look at it, both are chair, both have their patent registered. Now, A while but B practices patent, there could be possible infringement on broader claim of A. So B does not get an affirmative right to practice his invention, but does give B a negative right to exclude others from making a selling of a rocking chair. A is now blocked, even though his patent broadly covers any type of chair. Now A has a patent which discloses a specific example as a pioneer in the product and has a broad claim interpretation leading to any type of chair in his patent. But B independently claims a patent for a rocking chair, referred as improvement in patent. So if there is an enhancement in the product or if there is an improvement in the already invented product and that part is not covered under a patent specification, the other party can claim only to that improvement part patent right on that particular issue. Right? That is how the affirmative rights is a negative right works in the patent specification. It gets very technical if I get into detail of how a patent works. But for a broader understanding, this would give a information as to how the patent regime, how a protection is granted for an inventor under the Patents Act. Right? Term of the patent and its feature. Now, term of the patent, the patentee, the inventor is granted a period of 20 years and then further period subject to application for renewal of the same. Inventions relating to atomic energy are not patentable. These, anything with respect to atomic energy, an invention is made, it's not patentable. Application to be filed with the patent specification with the patent authority online through an agent or the inventor himself can file the specification. Application shall be kept with the publication without publication for 18 months. After the examination is done, the registrar of patents will publish the specification on the online portal. There will be a specific number that will be granted. If any objection is raised by the examiner or if there is an opposition pre-grant that has been posed by another inventor, that will all be heard by giving an opportunity of hearing. And then you always have the option of post-grant opposition also. It's not like if an inventor is getting the right, you cannot challenge the the patent that has been granted. That's where the role of lawyer comes into picture when there is a post grant opposition that is there for a particular product. Right? The process is as such: you file an application for provisional registration, or a specific complete specification can be filed at the first instance itself. Publication of the application, and then you request for an examination with the registry. Any issues or objections that is raised, that will be considered. An opportunity of hearing will be given to the inventor or the person authorized to represent the inventor, and then grant of patent. If there is a post-grant opposition decision of the controller, and then the appellate board. After the appellate board, if there are any technical issues, it will go to the High Court. Otherwise, it will go to the Supreme Court. Now, there is a lot of issues with respect to Patent Act. Patentability of a life-saving drug. This is one of the examples that which is relevant at this point in time for everybody to understand. Right? Novartis AG versus Union of India. The IPAB, the Intellectual Property Appellate Board, had held that the invention satisfied the test of novelty and non-obviousness, but the patentability of a product was hit by Section 3D of the Patent Act, where there are certain sections if life-saving drugs cannot be patented. Now, Supreme Court in its judgment made it clear that India is a developing country and the availability of medicine at a cheaper rate is necessary for lives of 1 billion people. Section 3D of the Patent Act 1970 prevents by obtaining secondary patent by introducing minor changes in the existing technology from these big pharmaceutical companies. Now, there is this concept called enhancement in efficacy. Now, if a drug is there, so for example, you have Dolo 650 for which is a paracetamol drug. Now, there is an enhanced drug called Combiflam, which is used, which has a combination of another drug along with the that itself is a patentable product because there is an enhancement in efficacy. It not only cures, not only brings down the fever, but also cures the body pains that has been caused. Right now, whether the invention beta crystalline form of impervine mesclate claimed by Novartis is more efficacious than a substance that was derived from impervine mesclate. Now, Novartis failed to prove that the therapeutic effect of the product is more compared to therapeutic efficacy of this one, so that the application of Novartis for patent was rejected. Initially, the patent authority thought that yes, there was a novelty, there is no obvious this thing, and then the product was capable of being patent, but it was hit by Section 3D because product which is the product which is a life-saving drug, these cannot be given patent. There are advantages and disadvantages to this. In a country like India, we need medicines at a cheaper rate, and generic medicines are there now. If there is a slight difference or a process of manufacture is different from the manufactured product by the original manufacturer, you can always claim that it is a novel product and then go ahead by saying that it's there is an enhancement in efficacy. That is how the patent regime works in India. Now let's move on to the next part with respect to understanding what is trademarks and how Trademark Act is governed. The Trademark Act 1999 was enacted by the government of India by complying with the trade-related aspect of intellectual property rights by the WTO, obligation recommended by the WTO, which replaced the Trademarks and Merchandise Act 1958. Now, what is a trademark? What is a mark or a trademark? Right? Section 2M of the Trademarks Act 1999 deals with mark, which says it includes a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of good, packing, or combination of colors, or any combination thereof. Right? That is a definition of mark. Now, definition of trademark, it says trademark means a mark. It says it's a mark, which is an exclusive, exhaustive definition. Trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others and make include shape of goods, their packing and combination of colors. Now it's a very exhaustive definition if you see. It says it should be capable of being represented graphically. It should distinguish the goods or services of one person from those of others and may include shape of goods, their packing and combination of colors. And in relation to chapter 11 of other than section 106, a registered trademark or a mark used in relation to goods or services for the purpose of indicating or so as to indicate a connection in the course of trade between the goods or services as the case may be, and some persons having the right as proprietor to use the mark. And in relation to other provisions of this act, a mark used or proposed to be used in relation to goods or services for the purpose of indicating or so as to indicate a connection in the course of trade between the goods or services as the case may be, and some persons having the right either as proprietor or by way of permitted user to use the mark whether with or without any indication of the identity of that person and includes a certification, trademark or collective mark. Now, it's a very exhaustive definition. Now, trademarks, few examples of trademarks I have provided on the, if you look at this slide, it says, now you have Motorola, Apple's logo, Facebook, Samsung, and then there are various other products that I have listed in the slide. Now, when I see this product, I associate particular goods, a quality of goods, right, or a quality of service when I look at, say, these logo, right? Now, what does the Trademark Act protect? The Trademark Act protects the name, mark, or a brand that you create for a particular product or a service, right? It's a distinctive sign that identifies certain goods or services produced or provided by an individual or a company. It helps the consumer to identify and purchase a product or a service based on whether its specific characteristics and quality as indicated by its unique trademark. Right? When you see a particular shoes with a tick mark, you will identify that this is a Nike shoes. Right? There is a particular quality that is assured that if I buy this product, that product will be of a particular quality. There is particular specification that they have provided in their web portal, or there is a specification that you get. The features have been explained. So you have a particular idea as to what a trademark is, or what the product's quality is, what the logo or the mark is associated with the particular product. Now, if you watch, uh, if a if a cinema has been produced by, say, Yash Raj Films or say, the production house or 20th Century Fox, they have their sound which is there in the initial clip, right? Those have been trademarked. Now, Rajinikanth's this thing when a movie is released, you get that superstar Rajini, right? Even that is trademarked by Rajinikanth. Now that's how the trademark work. It not only protects the word, it protects the mark, it protects the logo, and it protects the service mark. Now trademark and are these kind of logos you may have seen on a particular brand or a product. Now trademarks is designated by three marks: TM, SM, and R. Now TM is used for an unregistered trademark. It is used to promote a particular brand. Now, once you have a new company or a new proprietary name or a particular brand, now if you file an application with the Registrar of Trademarks, you can start using this mark called TM on that particular logo or a word that you use. SM relates to an unregistered service mark. It is used to promote a brand of a service. Now, R is when you uh, put the logo as R on the particular product. Once the registration of the trademark has been approved by the registrar of trademarks. Right? Now, what is the procedure to avail a trademark or this thing? What is the filing? What are the classes under which you can file? In India, the intellectual property rights, you have this ipindiaonline.gov. I'll provide the link for ease of understanding and reference, so that you can log into this, and then this is the registry where not only a chartered accountant, company secretary, or a lawyer, even the person himself can file the application for availing the trademark. To be a trademark agent, either you will have to be a qualified professional under any of these three institutes, and a lawyer and advocate also is qualified as a trademark agent. What you have to do is you'll have to register yourself with the digital signature on the online portal, and then you are the trademark agent number, a trademark number is allotted to you, become a trademark agent along with your professional qualification. Now, under what category do I apply for a particular trademark? Now, in India, you have 45 classes under which you can apply for a trademark. If you're providing legal services, if the brand or the logo is associated with a particular mark with respect to a particular service, you apply under class 45. For say software, you will apply under 10 and 16. These are the classes under which you apply, and then put the thing saying that, say for example, Samsung wants to register one of their softwares, one of their new branding under particular category. So they can file an application, one application for various categories, or they can apply for particular category under particular class, which is there under 1 to 34 and 35 to 45. I will share the slides with the institute. The institute will share with you. I have provided the hyperlinks where you can have a look at what kind of classes the trademark can be applied. There are certain class with respect to well-known marks. So if I am a well-known mark, for example, now Google, Apple, 7 o'clock blade, right? All these marks are considered to be a well-known marks. They have been published under the on the website of the intellectual property rights registry, where it says these are the marks which are well-known in the country, right? These marks have attained well-known mark in the world. So you can't just file an application or imitate these while filing for the application. Now, what does a trademark registry look at? Now, trademark registry looks at whether there is a distinctiveness that is being carried out by the particular word or a logo or this thing which is distinct from the product. And say I can't apply for an Apple on an Apple logo, right? It should be different. Apple for phone or an tab or an electronic device, yes, it is accepted, right? It is not obvious. It is not an thing which is very obvious. It's not on a particular fruit. So when I say Apple products, you don't think about fruit, but you think about a particular electronic device. Now, this protection is granted by the Trademark Act under the TRIPS regime, where a particular logo or the word has been given protection under. Right now, whether the Trademark Act protects the domain name as well. Yes, domain name, when I say www.yahoo.com. There was one case with respect to Yahoo Inc. Yahoo Inc. was an US established incorporated company. Here in India, Akash Arora and others were, Akash Arora had, applied for the domain name yahoo.co.in. And then Yahoo had to file a trademark infringement suit, and then say that Yahoo has obtained worldwide recognition. And then the court ruled in favor of Yahoo, and Akash Arora had to, transfer the this one, domain name to Yahoo, because there was protection that was granted by the Trademarks Act. Right? Now, when does a trademark infringement take place? Now, the most important point that we need to prove is the products are deceptively similar. That is when you can claim injunction or claim the exclusive right. Now, you see various products in the market which have infringed the exclusive right or a product infringement. What happened is Colgate family company had manufactured this tooth powder. Now, Anchor also manufactured the tooth powder, but they use similar kind of box to sell in the market. Now, the courts look at it in a different way. So when they don't do the side by side test, you don't have the side by side test. Now, what happens is when I see this product, I remember a particular shape, product, or a design of the product. And then I go back, I come back to the same shop, I may pick up Anchor, right? The court restrained Anchor from using the color combination of red and white in order to container packing of this good with respect to tooth powder. It's a particular class of product where 200 grams of product is there. Then this gives a clear idea as to what is a deceptively similar product, where it causes confusion in the mind of a buyer. The prior user or the person who's got the registered trademark will be protected from another person infringing the rights which has been conferred on him. Right? Now, this is another interesting case of trademark infringement where Hudson Argo product had Arogya milk, and then Patanjali had Arogya biscuits. Now, they are different class of products, but they are uh, edible products, right? So, Hudson Argo took too much time to sue Patanjali. That is one of the reason there was delay in lashes in claiming your rights with respect to the particular product. The court ruled that Patanjali had, with respect to its brand, had spread its market, and then it was with respect to a different product altogether. So Patanjali, there was no injunction granted, or there was no restraining order granted to the Arokya for them to sue upon Patanjali. So they both have their different market, and they proceed with this. So whenever there is an infringement, the courts will look into one aspect: how immediately you have acted upon it. This Patanjali biscuit came in 2014. By the time they sued, it was more than a year. They said they have acquired particular share of market in the particular share in the market. So it can't be an infringement because they have got their distinctivity, and there is no dissimilarity or deceptively similar product which will cause confusion. You are a milk, and this is a biscuit, and two different products in the market, and you have different share. Nobody gets confused with your same brand, and the brand is not uh, same. It is under Patanjali Arogya. Aspect of copyright, the most important person is the author. In relation to a literary or a dramatic work, the author is the author of the work, right? I'll come to discussion as respect to what is work, right? In relation to a musical work, it's the composer who's the author. In relation to an artistic work other than a photograph, the artistic the artist himself. In relation to a photograph, the person taking the photograph is the author. In relation to a cinematograph film or sound recording, the producer. And in relation to literary dramatic work or an artistic work, which is a computer generated, the person who causes the work to be created. Now let's understand what is an artistic work. A painting, a sculpture, a drawing, including a diagram, map, chart, or a plan. An engraving of a photograph, whether or not any such work possesses artistic quality or not, work of architecture, any other work of an artistic craftsman, dramatic work to a non-dramatic work, conversion of a work into a dramatic work by way of performance in public, reproduction of a book or an newspaper, magazine, or a similar period. It's an adaptation. All these are governed under the Copyright Act. Now, copyright protects literary and artistic work, right? What do you mean by literary and artistic work? It's a huge gamut of uh, a series of things that the Copyright Act protects. The literary and artistic work shall include every product in the literary, scientific, and artistic domain, whatever may be the mode. So literary and artistic works covers everything under the sun, which you can express it. If you take a photograph, photographer is protected under the Copyright Act. The beauty of copyright is you don't have to register something. So you take a photograph and then you put a logo called C. The copyright belongs to so and so. It becomes a copyrighted material, right? So if I write a book, if I make this presentation, right? If I am authorizing I become the author of this PowerPoint presentation. I give it to the ICAI and say the rights have been granted to ICAI to use this PowerPoint presentation in whatever manner in which the ICAI may use it. I am assigning my right on the copyright to the institute, right? So I make a particular plan or a sketch. An architect makes a particular plan or a sketch for a drawing or a drawing. Those drawing belongs to the professional, and then he gets protection under the Copyright Act. I write a book. There is a Bare Act. So I write certain comments on the Bare Act, right? The comments are my original work. Or say there is an act and there are rules. Now, an act refers to a particular rule. I extract that rule and put it in the book and publish it. Now, once I publish it, it becomes my work. It becomes an original work in my name, right? So there is something called remix of music. There is original music that the composer does, and the singer sings that composition, right? And then there is another DJ or a music composer who mixes 2 or 3 songs and makes a particular music. Now, there are two schools of thought. One says the remix is a original work or an adaptation of a particular original work, or the other person says remix is an original. It's an infringement on the original author if it is not if the assignment or license is not being taken by the person. The Copyright Act says you can't commercially exploit a particular thing. I can't take a particular cassette or a DVD and play it in a mall when I have my shop, because if you see particular shops, they would have certain licenses or permission to play it in a public. That is the actual procedure under the Copyrights Act. You need to take the permission from the producer of the music to play it in your shop, because you may be entertaining him, but it may not be a concert or a thing, but you need the permission of the original author of that work. Otherwise, it will be an infringement of copyright. But most of the things will not be, most of the music thing will not be pressed upon by the author. But mostly with respect to copyright on a software and other things, there will be, they'll press upon it for infringement with respect to a software or a book or anything, right? Now, I said works under the Copyright Act. Now, the Copyright Act governs the grant of authors, artists, and other creators protection for the literary and artistic creation. Generally, it is referred to as work. And the beneficiary of the related rights are performers, such as actor and the musician in the performances, producer of phonogram, for example, compact disc in their sound recordings, broadcasting organization in the radio and television programs. Now, music that has been played in the radio, they have the broadcasting rights. It has been granted by the performers or the producer of the work, right? Now, let us see the circumstances under which the act or person will be a deemed infringement act, right? When a person does not have a license to use copyrighted material, and in any case he has a license, he acts in contrary to it, it includes making and reproduction of unauthorized copy of any performance in public. When a person makes copies for the purpose of sell, sale, or hire, distributes and exhibits in public for sale of trade which adversely affect the interest of the owner, imports any infringes copyright works. Right? Now, what are the infringed works? Now, in terms of software piracy, right? You might have seen this on YouTube. It says YouTube has taken down the copyright infringed material. This video is no longer available due to a copyright claim. Now, you go buy a DVD of a particular movie, and then you rip it and put it on your website, and then you put it on YouTube. Now, whether this act of yours is an infringement, according to me, yes. The producer of that particular movie can will write to YouTube, and YouTube takes it down, saying that it's a copyright infringement, right? DJ remix of work. If there is no originality in a particular work, that becomes a copyright infringement. Now, software piracy is there always. There are a lot of software which is available online on a demo version. You download it and you use a particular serial number. It becomes a copyright infringement. Now, how do we deal with copyright infringement? So, for example, if you are a chartered accountant or a lawyer with a software company, if they come and ask you, there is a company, say for example, you work for a company like industrial design software. You have a particular industrial design software which is protected under the Copyright Act. Now you provide licenses for usage of that particular software to various other companies. Now, how do I identify whether there are, say, for example, there is I was being appointed as a code commissioner in one of the products like Siemens. They have a software that they have developed, which is used to design the high-rise buildings and other kind of products. Now, this person has taken 5 licenses. All right, each license costs around 12 lakhs. But there are computers that have been running in the organization in that company. Now, how do I identify whether now if I look at it in my records as a owner of the product as Siemens, I have seen that 5 licenses have been taken by them, and then they are doing it. But how many licenses have been actually used by that particular person is something that we are unaware of. Now, how does a court look at it while understanding a software piracy? Now, there is something called a technical team or a forensic team that is very much required to understand examination of software piracy or a infringement of a particular product. In case of trademark, what they do is there are people who are there in the market going and buying these products. So they keep surveying the market to see if there are infringing products, right? So like something like the Cadbury's Munch is there. You have MUNCH, you have MANCH. So there are deceptively similar products. Now these forensic team of Cadbury's will go examine, they buy these products, they see who is the manufacturer. As per the legal metrology, you need to produce the details of the product. In case of food material, they have to they follow the FSSAI guidelines and then give the details of manufacturer and other details. Now they use this product, they click the pictures, see what is the market survey, they do a particular market survey as what is the percentage that has been captured by this particular product in the market. And accordingly, they approach the chartered accountant for evaluation of a particular market. And then based on the valuation that has been done on for that particular trademark or a particular software infringement which has been done, how do they do it? Now, the forensic team says, I have a particular project that needs to be done. How many days will you take? What is your team strength? And give me the details of your products and the license that you have. So they give a list of details as to these many people are there in my company who work day in and day out. This is the software that I have. Based on that forensic report, which is submitted to the company may use this and say a court commissioner needs to be appointed. Somebody has to come there, look into go into the company, make a particular, I don't call it raid. The court commissioner is appointed to go and inspect the premises. I've been appointed like 3 times by the court. There is no particular qualification that is required. You need to have a knowledge of the intellectual property rights as to how this works. And I don't need to know about the particular software as to how it works, how the license works. There'll be a technical team that will be supported along with the court commissioner. You will have to go to the premises, make a log of things as a court appointed commissioner. Say after entering the premises, I find these many computers. I have appointed so and so members as my team for inspection. The inspection team will inspect all the computers and say these are the pirated versions. These are the computers which has been using the softwares which does not have proper licenses, or there are servers which is a shared server. Whether the agreement provides for sharing of software on a particular platform. More than one user can use it simultaneously at the same time. Or this license, sometimes what happens is, in one of the cases, interestingly, they had purchased the software in Sri Lanka because the software was lesser, the amount of software was less. But if you see the license agreement, that license was granted only to Sri Lanka. Although they had software, there was an infringement of copyright because it was used in India, right? So what happens in that case? I write these things. The court commissioner will seal down those products and take the signature and undertaking saying that I will not use the product unless I seek the leave of the court. And then I submit this report to the court. Now, the product gets seized. The product, although will be lying with the defendant, and then they come back. Now, one of the other case, what happened? There was a second time that I made visit to the company. There was a call center. This was with respect to Microsoft. Now, Microsoft licenses with respect to servers, right? There were 200 plus computers. The team of investigators went inside. They had to see what all there was. 3 or 4 licenses and other licenses were not provided. We had to shut down the whole uh, call center, and then these matter get settled without any issues because the manufacturer, the software providers also know that these are the people who are the market for the product, right? They can't have at least they buy 80% of the license, they'll be happy because these kind of licenses are Microsoft is the most In India, at least the software is the most pirated software that is being used in terms of Microsoft Office and even the operating system. So now most of the laptops and computers comes with preloaded operating systems. So there is protection. There is a cover under the copyright region for that aspect. Now, this is how the software related thing works in the copyright region. So, one of the exception, what covers copyright? Now, when we go to the court, when we go to say ITAC or say commissioner for hearings for on various aspects, we use the case laws or the books for reference, right? We make photocopies of this. Whether the photocopy of a copyrighted material, say for example, I use chitty on contracts. There are certain books that I use of an international journal or a journal. I photocopy it and produce it before the court or the tribunal. Or I use a particular extract of a journal in my presentation for educational purpose. Whether that is considered to be a infringement on copyright. No, that will not be considered to be an infringement of copyright because it will be termed as a fair use, right? Fair use or fair dealing. Exception to the act of infringement is fair use is always interpreted by court depending on the facts of each case. Copyrighted material in educational institutions. This will be considered to be a fair use in terms of Copyright Act. Now, one of the interesting cases that went up till High Court and then the Supreme Court was Chancellor, Masters and Scholars of University of Oxford and others versus Rameshwari Photocopy Services and others. DU photocopy case, famously known as. Now, what happened is Delhi University has certain economic students. There is a photocopy shop which is there outside the Delhi University, which makes compilation of a copyrighted books for students for reference. Now, these Delhi University and big publishing houses got to know about this issue in 2012, like Oxford University Press, Cambridge University Press, and Taylor and Francis Group. They got to know that this has been done by a photocopy shop known as Rameshwari Photocopy Shop in Delhi University. They were accused by the plaintiff that they regularly compile up the data of copyrighted books published under the publication and provide it to the students, and they are making money. Now, the Delhi High Court said copyright, especially in literary works, is thus not an inevitable or divine or a natural right that comes or confer on authors the absolute ownership. Section 52(1)(1) of the Copyright Act is wide enough to include the acts of photocopying and the creation of course packs by university for its student. Further, court observed that if Delhi University can photocopy, so can its agent Rameshwari Photocopy Shop or any other photocopy shop, whether inside or outside the university. Now, the Delhi High Court held that for educational purpose, you are making a photocopy, it can't exceed a particular percentage of a particular book. That doesn't give me a right to photocopy the entire book for my educational purpose. So it should not exceed a particular percentage. If I am right, it should not exceed more than 60% or 40% of the book. Now, next part of the presentation will cover on geographical indications. Now, geographical indications, if I have to give an example, is in Karnataka, it's Mysore silk, right? Mysore Mallige, or say agriculture with respect to basmati rice, natural Makana marble, right? It has a geographical indication. Handicrafts or any, for example, Pashmina silk of Kashmir, Mysore silks here in Karnataka, foodstuff, for example, the Harvard Peda, they have an identity towards a particular geographical location, right? So they are geographical indications which are protection under GAI. Under the Geographical Indications of Good Registration and Protection Act under 1999. This is with respect to agreement on trade-related aspects of intellectual property rights. The TRIPS agreement sets a minimum standard of protection for goods registered under as a geographical indications. The Geographical Indications of Goods Registration and Protection Act 1999, along with that rules, governs the geographical indication registration and goods. Now, Section 9 of the Geographical Indications of Goods Registration and Protection Act 1999 names a few exceptions which cannot be registered under the geographical indication. These are the goods which may cause confusion or deceiving the public. It may be scandalous in nature. So, any contrary to the law enforced at the time may hurt religious sensibilities, any generic or non-unique. Now, if they are not unique, now, for example, Mysore silk has attained a particular quality standards, right? Pashmina silk, for example, you know that when I say it is Pashmina silk from Kashmir, it has a particular softness or a particular texture of the cloth material. If I say Mysore silk, you know that it's of a particular quality. Say Assam Darjeeling tea, right? Darjeeling tea, you know that there is a particular quality of taste that you get from a particular product. Now, Darjeeling tea, basmati rice, you get that particular smell. Now, very interesting case was of Scotch whiskey. Now, when I say Scotch, if it is only from Scotland, it would be referred to as Scotch. Any other whiskey can't be termed as Scotch whiskey. There was a case that was filed in Delhi High Court. It's a definition of Scotch whiskey under UK Scotch Whiskey Act. They have a particular act in the UK, and the Scotch Whiskey Order 1990 accorded status of geographical indication to the product. Now, you don't get Scotch in India. You will only get Scotch in the UK, which is manufactured in that particular area, Ireland. Right? You will not these products. If it is manufactured, whiskey is manufactured elsewhere, it can't be termed as Scotch. Now, basmati patent. Now, what happened why is this geographical indication very important? Now, the US Patent Office granted patent to Rice Tech for a strain of basmati rice, an aromatic rice grown in India and Pakistan for centuries. Right? But one of the US company called Rice Tech got a patent for 3 strains that is developed by Rice Tech and allowed patent protection, and they are eligible to label its strain a superior brand of basmati rice. Now, this is an unfortunate thing that happened earlier, and then later India had to wake up and then formulate particular this thing. They got the UN Patent Office had to revoke patent that was granted to turmeric, which said it as obvious and anticipated, and then agreeing that the use of turmeric was an old art in healing wood. Therefore, the trade that belonged to India was to be safeguarded in turmeric case. Right? The US Patent Office revoked the patent that was granted to turmeric, saying that it's a prior art, it's a already existing this thing, and it's a the geographic this thing belongs to India, and it's a prior art which is there in India. Neem also, the patent for Neem was first filed by R.R. Grace and Department of Agriculture in USA in European Patent Office, protecting agriculture plant from fungal infections. Now, UPO identified the lack of novelty, inventive step, and possibility from a relevant prior art and revoked the patent. Apart from this, several US patents were recently taken out, neem-based emulsion and solutions. Now, the farmers use neem oil for as fertilizers, and you know that has fungal production from fungal infection. Now, there was a patent that was granted to neem plant by to an US company, and later on, by application by the Indian government, the patent was revoked. Now, what India did as an effort with revocation of patents on worldwide thing, they introduced something called Traditional Knowledge Digital Library. Now, it is available online as to our old age, old this thing with respect to Ayurveda, Siddha, Unani, and yoga. Now, what they did is they published this thing around traditional knowledge digital library. India's effort on revocation of patents on wood healing properties of turmeric at the US Patent Trademark Office and the patent agent granted to the European Patent Office on antifungal properties of neem. India's traditional medical knowledge exists in local languages such as Sanskrit, Hindi, Arabic, Urdu, Tamil, etc., is neither accessible nor comprehensive for patent examiners at International Patent Office. It was identified by Trade Traditional Knowledge Digital Library Expert Group in 2005 that annually around 2,000 patents were granted around the world erroneously concerning Indian system of medicine by patent offices around the world. Traditional Knowledge Digital Library provides content of the Asian texts on Indian system of medicines, that is Ayurveda, Siddha, Unani, and Yoga, into 5 international languages, namely English, Japanese, French, German, and Spanish, with the help of information technology tools and innovation classified system, traditional knowledge resource classification, biopiracy, and misappropriation of traditional knowledge. After the Basmati case, India had to do these efforts with respect to the traditional knowledge and protection of the plant varieties and other things by creating a traditional knowledge digital library. Right now, other important aspect under the intellectual property rights is the trade secret. Now, confidential information, database, non-solicitation, non-disclosure. The Coca-Cola's trade secret, which remains one of the benchmarks in. There is no specific act governing trade secret under the intellectual property regime under the act. But trade secrets have been protected as an intellectual property under the Contracts Act. Now, for example, I create a database. For example, Just Dial as a database. The courts have always been protecting Just Dial database with respect to this one, the database that they have created for all kinds of manufacturers, service providers, and this thing. So a person who is working with the company like Just Dial will have to enter into a non-disclosure or a non-solicitation agreement. There is a particular amount of money that is being paid towards non-solicitation. If I work at a managerial level or a technical level of Just Dial, I can't form an other company just like Just Dial and take all the data that is available with Just Dial. Right? That is how a trade secret or a trade knowledge or a data is protected under the Copyrights Act there in that case. Confidential information. If I create a particular confidential information, if I am the person, I am an advocate, I invest in a company of and I form as software engineers to create a database of particular chartered accountants or lawyers or professionals, right? I appoint a chartered accountant and I appoint a software engineer and create a particular database. Now, after the database is done, he knows that it's a particular worth and he knows the market. He can't take away this data that has been there under the company which I have created, being the director and shareholder in the company. He can't take away as an employee can't take away these products which is there as a confidential information and start another company. I can restrict him if substantial part of it is same for a particular period of time, right? So that the infringement of my right doesn't take place. Now, that is with respect to trade secret. Trade secrets have not been protected under the intellectual property regime, but trade secrets are governed under the aspect of contracts, copyrights, and wherever the information falls within the scope of intellectual property rights. Now, another interesting act which is there in the intellectual property regime is the Designs Act. It came into force on 12/5/2000. It's a design of a particular car, bike, or a particular this thing. Which design? What does a design mean? Right? Design means feature of shape, pattern, configuration, ornament, or composition of colors or lines, which is applied in three-dimensional or two-dimensional, or in both the forms using any of the process, whether manual, chemical, mechanical, separate or combined with within the finished article appealed to or judged wholly by the eye. So it should be wholly judged by an eye. So for example, if I create a particular car design, now the car design is made through, say for example, 3D designing softwares, three-dimensional designing software. I make a particular design of a particular car. Now that can't be exactly same by another person. That is covered under the Designs Act. Now, if it gets covered under the Designs Act, you don't have to seek protection under the Copyright Act or a Trademark Act. Design protection is given for a period of 15 years. Now, only these kind of the Section 5 of the Designs Act provides for application for registration of design. It's very important for us to understand this section. The application for registration of design, the controller may, on an application of a person claiming to be the proprietor of any or the original design not previously published in any country or which is not in contrary to the public order or morality, register the design under this act, provided that the controller shall, before such registration, refer the application by an examiner appointed under subsection 2 of section 3 as to whether such design is capable of being registered under this act and the rules made thereunder, and consider the report of examiner on such reference. Every application under subsection 1 shall be in prescribed form and shall be filed with the patent office in prescribed manner and shall be accompanied by the prescribed fee. A design may be registered in more than one class and in case of doubt as the class in which a design ought to be registered. The controller may decide the question. The controller may, if he thinks fit, refuse to register any design presented to him for registration, but any person aggrieved by any such refusal may appeal to the High Court. Any application which, owing to any difficult default or neglect on the part of the applicant, has been completed so as to enable registration to be effected within the prescribed time shall be deemed to be abandoned. A design, when registered, shall be registered as one of the date on the application of registration. The part subsection 6 is same in case of all the copyright. Once it gets published, you get the protection. Trademark, you may file the trademark today, you may get the trademark registration certificate after 3 years or say 6 months. But the registration is dated from the date of your application, right? So that is with respect to registration. Now, prerequisite for a registration for under the Designs Act after reading Section 5. It should be a novelty and an original design. The design must be unique. A prior publication is not acceptable. Making application of a design to an article. The design must not be contrary to order and morality. The design must be capable of registration under Section 5. Now, we have understood the prerequisite under the Designs Act. So, when a proprietor applies for registration of the design, he shall automatically get copyrights in the designs, right? He gets automatic protection under the Copyrights Act also when I make an application under the Designs Act for a period of 10 years from the date of registration, extended for another 5 years. Maximum that you get a protection under the Designs Act is for 15 years. Author of the design acquired design for a valid consideration. Any person to whom the design has been devolved from original proprietor. Now, the Designs Act is a very peculiar act under the intellectual property regime. It does not include any mode of construction of any trademark. So when you have a Designs Act protection, you can't go say that this is a mark and claim protection under the Trademarks Act. It does not include property mark as defined in section under. It's not a property which is defined under or a property mark which is defined under the Indian. It does not include any artistic work as defined in the clause 2 of section 2 of Copyright Act, which we discussed earlier. Now, one of the interesting case that I want to discuss with you with respect to Designs Act is the Crocs versus the famous case of Crocs versus Bata Limited and other shoe manufacturer. Now, Crocs is a famous brand of the US entity. Again, Bata is there in India for quite some time, right? Now, what happened is, if you see this Crocs shoes, right? This Crocs shoes had got protection under the Designs Act. Now, as you know, as I discussed in section 5, and the term of designs under the Designs Act, you automatically get protection under the Copyright Act for 15 term of 10 plus 5 years. Right? You get protection under the Designs Act. You can't claim protection under the Trademarks Act when there is a valid and subsisting designs protection. Now, Crocs had got designs protection. So Bata and other companies realized that 15 years is over for the Crocs, that design they've got. They started manufacturing similar kind of this thing with a different kind of material which is being used by Bata, Liberty, Aqualite, Action Shoes, Relaxo Footwear, and Kids. All these manufacturers started manufacturing something like Crocs, which was available in the market. It's still available in the market now. Now the Crocs found that after protection of 15 years over, they applied protection of this design or the mark before the trademark office. Now, single judge of the Delhi High Court said there is no infringement. The division bench of the High Court also said there is no infringement, but there is a trial that needs to be going on. So the matter is still before the Delhi High Court for determining whether there is a infringement of trademark in this regard or on the design aspect after 15 years of the product has been launched and which is there in the market. Right? This is with respect to Designs Act, which has a very limited scope on designs of particular manufactured goods. Especially, it covers 3D dimensional drawings and 3D of a particular product and not otherwise. Right? Now, what happens if there is an infringement? Right? We'll be finishing in another 10 minutes, then we'll be open for questions on all the aspect that we've discussed. And then with that, we can close. See, what happens if there is an infringement? Now, we discussed in length with respect to patents, trademarks, copyright, geographical indications, and then designs, right? With this, my second slide has already been answered with respect to whether I can protect my copyright, trademark, or treatment. All these aspects are different aspects under the trademark regime. No, they are. This presentation is only to give you an insight or what is that a chartered accountant can do with respect to intellectual property rights. Now, when I discussed with the chairman said, chartered accountant is the first person and person would approach for formation of a company or formation of a particular business or comes with a business idea. Now, when I come with a business idea, it is very important for a chartered accountant or a professional like us to know each aspects of a particular product or a particular this thing. If this product is already there in the market, if there is already a product there in the market, how do I suggest you or tell you as to this is something which you are violating? Also, for example, I am establishing a business with so many computers, so many things. Should you buy licenses? Right? That is one aspect. The other aspect that we need to look is valuation. Now, valuation of it, the chartered accountant is approached for valuation of shares, valuation of the company, valuation of the goods, valuation of inventory, valuation of goodwill, so on and so forth. Now, how do I determine valuation of a particular intellectual property right? Now, that is one question that needs to be answered. I'm sure a few of the chartered accountants, or most of the chartered accountants would have come across in their life as to how do I value a particular goods. For this, it is very important for you to understand intellectual property. Now, with this, I have covered all the briefing with respect to what an intellectual property right is. Now, what happens in case of an infringement action? While discussing Copyright Act, I said one aspect is having a forensic team to understand how do I go with the infringement action. There is a particular step before going to the court. You need to have done your homework with respect to what is that has been violated. What is the value of the product that has been captured by the market? What is the value of the infringement that is done in terms of patent, in terms of my invention being infringed upon by another person, right? What is the value of market that I have in the market, or what is the potential market? That valuation can be done by the chartered. plays a very important role in understanding the market and market situation with respect to what is the product, what is the market for that product, right? In terms of invention. Number two, in terms of trademark, right? If I have an athletic, somebody has violated a trademark of a Nike shoes, for example, and has different kinds of shoes which is having a similar kind of logo. I know what is my market. They do a market study, and then there is a books of account that needs to be prepared. If there is an injunction that is being going on, if both parties, if the defendant is not being restrained by the court by an injunction order, a stay order is not granted for him from manufacturing, they have to maintain a separate books of accounts for the product that is being kept under, which is there under the litigation. So, for example, I have a particular brand of shoes, and I feel the defendant is infringing upon my product. The balance of convenience right lies between with the other person, saying that maybe at the prima facie doesn't look like he is violating the intellectual property with respect to trademark of mine. Let him maintain separate books of accounts with respect to that particular product which is being getting sold. If plaintiff succeeds, the defendant would have to pay the entire books and profits to the plaintiff. That is when the chartered accountant's role come into play with respect to how do I maintain a particular uh, books of accounts to that respect. I'm sure your accounting standards and the manner in which the books of needs to be maintained, you will be in a better position to understand as to how evaluation needs to be done, or how a separate book of account for that particular product or a trademark that needs to be kept, right? That's one part. Number two, I identify a particular product. So, for example, Nexus is one of the brand that has been created by Maruti, right? If somebody tries to use the Nexus brand in a particular class, Maruti will file their objections immediately. When during the file, what happens is there is a journal on which the trademark is published. Right? Immediately, a forensic team will identify that there is an infringement on that particular thing. Somebody is trying to file their um, application under that particular class, which I have jurisdiction, which comes under my domain, my trademark, my infringement of my mark. So you file your objections at that the first instance instead of waiting till they actually have the product in the market and infringe upon your product. So the first thing that is, there are two remedies that is available. One is filing of an stay order or an injunctive relief, restrain the other party from using this product, right? That's one part. Second part is filing for damages. The third aspect is criminal law. Criminal law, uh, you file an action if there is violation, you know that it's a blatant violation of a particular product, you're trying to deceive the party, it becomes a fraudulent action, then you have criminal action for infringement of a particular intellectual property rights, right? They're all civil remedies and there are criminal remedies. Like I discussed, chartered accountant role is there in identifying and understanding how to maintain books of accounts, valuation, and other things. And it's very important for professionals like chartered accountants and advocates to understand intellectual property rights, because you're at the end of the day advising business to achieve their goals, right? Now, the this thing is initially is the intellectual interlocutory relief, that is an interim relief that is granted. Later is the permanent injunction, like permanently restraining the other party from doing it. And then additional and exemplary cost is granted in uh, any IPR infringement cases in terms of civil remedy. With this, I close the this thing session. Any questions that you need to raise, you can raise. Hello. I have a question. If objection is filed in courts of country by an MNC and it fails, can the company approach a court outside the country or the world court? Now, to answer this question, this is a question from Narendra Telang. He says the objection is filed in the court. Now, see, trademark IPR is a country-specific registry. Each country will need to file your application for protection, right? So if there is a trademark that is violated in India, you will have to file your complaint before the district court, or if it is an original court in Delhi, Calcutta, Madras, you need to file it before the original Bombay. You will have to file it in the High Court for infringement of any of the intellectual property rights. If it is an outside country, if you identify, if you have not got any protection, if it's a multinational company, multinational companies usually have registration wherever they have their presence. So each country, they'll have to file their, if it is in US, you'll have to file it before the US courts. If it is in India, you'll have to file it before the Indian courts. That answers the question which is raised by. Any other questions that any of the participants is willing to ask and be.
1 second, sir. It is in the question box. It is mentioned few questions.
Yes,
Let
sir,
me
please.
read. One second, sir.
Yes, sir. One question is there from Prasanna Kumar, which is with respect to court commissioner appointed and raids that have been conducted. I discussed with you with respect to copyrights, right? Copyright, which said a court commissioner is appointed. Now, before doing, let me explain the procedure as to how a copyright infringement action suit is raised. Now, for example, I'll take the same examples of Siemens in respect of infringement action. Right? What they do is they have a forensic team. The forensic team takes a report from the. So I go as an individual saying that I am your client. The forensic team goes as a client to the company, saying that this is the project that I want. Please give me so and so details. They may pay their professional fees also, and then collect invoices and other things. They say that I will complete this project within 5 days. With 5 licenses, you can't complete that project. Right? It's humanly impossible with the 5 license. Now you get to know that there are more softwares. Okay, that I file an infringement application, that I may find some infringing material in the defendant. So it is very evident that a court commissioner under the provisions of the CPC needs to be appointed by the court for examination. So what the court does is, court will see if there is prima facie case, if there are enough evidence that has been produced by the plaintiff while filing this thing, saying that what is the repute of that company, what is the damage that is caused. Now, if a court commissioner is not appointed, the whole case fails, because the notice goes to them saying that you have violated so and so software. He'll start deleting it, or he will try reducing it to 5 licenses, right? So the court commissioner, the plaintiff has to identify the persons who is a court commissioner. It can be anybody, a lawyer or a chartered accountant, or anybody for that matter, who has a knowledge of chartered account, who has a knowledge of intellectual property rights, can give the plaintiff can give their names to the court, saying that so and so may be kindly be appointed. It's the discretion of the court, and court will see who is practicing on that particular area, who is there in that court, who is presented a case on that particular matter. Any third party, any person who is neutral, who doesn't have any conflict with that particular case, will be appointed as a court commissioner, and the court will determine what fees needs to be paid to the court commissioner. That has to be paid by the plaintiff himself, and he has to arrange for everything, right from pickup to drop to if he has to go to another state for doing this commissioner work, he has to pay the cost. And after he's prepared the report and presented to the court, he may seek for an enhancement of his court commissioner fees also. So before going and filing a suit before the court, the multinational company or the company who is the owner of the software has to do the background work. Only then you get this thing. It's only because, so you and I may know that you may somebody is using an infringing software, but only after the court grants, only if the court grants the permission, they can actually approach the company for this thing. Otherwise, if the company refuses to allow the court commissioner to go inside, it will become a criminal action. It will become a contempt of court, which will be as good as accepting the charges that is being levied by the civil court, and there will be extraordinary damages or exemplary damages that will be imposed on the defendant for not allowing the court commissioner to do his work. So with that, I
Yes.
answer one of the
Yeah,
questions.
I think whether this question is answered or not, I don't know. Bhargav SG has asked, is trademark one-time registration or it has to be renewed annually?
No. The
And
trademark is registered for a period of 10 years, and then you can continuously keep renewing it for further period of 5 years and etc.
and
For
trademark
example,
and
yes.
continued with that, trademark registration is product wise or one registration for the whole brand or company.
Now, one of the slides which I have shared, there are 45 classes in which a particular design or a logo or a word can be registered. It is on particular class. There are 45 class. 1 to 35 is on goods. 35 to 45 is for a particular class of services. 45 being for the legal services, consultancy services, other services is covered under 1 to 45. I'll share that link where you will have a brief idea as to what all classifications. So, for example, if I have to register a logo of Infosys, so although it may be for software, which comes under sections class 16 or class 10 or 9, now I may have to register under all 45 categories if nobody should use that category for any other. For example, Reliance Stationery is there. Okay, Reliance Stationery is not Reliance Stationery World in Avenue Road. That is not the brand of Reliance Industries Limited, because this is a particular different category. Some stationery, they are on a different category. There is no confusion in the minds of people when they go to these kind of shops. No, this shop is established much before Anil Ambani started retail trade on Reliance. So if I have registered in a particular class, there is no infringement on the other class which is already there in the market, right?
Yeah. That is, and under one of the active viewer of the branch, Mahesh Kumar Sumba, they have asked the question:
Yes,
is
sir.
it necessary to register a product or service in all classes to safeguard future usage of name, etc.?
So each class will cost 4,500 rupees for registration. Each class, each logo or each word will cost 4,500 rupees on each category. So if you have that kind of money to register and you want to register you to be very safe, you need to register under all 45 classes. But the court may not grant you on all 45 classes because you may not have prior user. There are two categories in which you can apply for trademark. One is existing user on a particular class. Number two, for proposed use. So within 5 years from the date of registration that you obtained, you will have to use the trademark. Otherwise, the trademark in that category will get lost.
Is not a match algorithm patentable?
No. Patent needs to be on a particular product which needs to be a novel this thing. So
Will this PP be shared? Yes, members, we are uploading the PPT in our regular website in background material, as you can get all our PPTs, and any of recorded program will also be in our YouTube in one or after completion of one day the program. Next question: an Arokya milk go into biscuits and get trademark?
Huh.
I think you have explained some
Yes, I
patent.
have
They
given
have
that
questioned
example.
that.
Okay, correct, correct. Now, what happens is there should not be delay in latches. Now, if there is a delay that has been created, what happened in this case? Patanjali had Arokya. Arokya would have got the infringement action done, but they were sleeping over their rights, right, for more than 1 year or 1.5 years. By that time, our Patanjali had acquired a particular vast area of market, right? They had their own brand Patanjali going. With that, it was established already. So when I already have an acquired market, I release something saying Patanjali Arogya biscuit, and it's not milk. That is a different category of a product. But if you see the trademark registration, this will be for a, it will be under the one category, one class called food category, right? Another class, food class, you would have registered Arokya. That is how you actually claim the product, saying that in this category they can't claim the registration. But the court will actually examine whether there is a market that has been created. It will not be free to give you this kind of thing unless you are a well-known trademark. So if they had approached within like 1 month or say 3 weeks from the date they release this product, maybe Arokia would have got the registration revoked or in stay on that particular product.
Yes, sir. Next question. In the case of duplicate drugs and other spurious drugs, how the control is taken care of?
No, the drug this thing is taken care of in a very serious manner. So, like I discussed, if there is an intention to deceive, if I have an intention to cheat the market by making an infringed product which is not a particular drug, right? There will be criminal actions under psychopathic narcotics drug. It comes in a different category altogether. It comes under the NDPS Act if there is a violation on terms of drugs and other things. It comes under the Indian Penal Code. It comes in a different subject altogether if I am trying to cheat somebody with a particular drug.
Okay. And can a copyright application be made in the name of a corporate body in case
Yes,
of software application developed?
yes. Tips, Z. These are all the companies who Akash Audio, Anand Audio. These are the companies who actually have the trademark. Copyright over the um, music, or Anand Audio releases a particular film music. So they have the copyright. Although the composer is the original owner, the company who produces the particular movie will be the owner of that particular copyright.
Okay, Hariprasad, I think all the questions have completed. Uh, it was an exactly a different topic for our members, though we are practicing in our other areas. And yes, as I said, the queries in our day to day it will come to, sir, I want to register one copyright, or want to register patent, trademark. Where to approach? We have to search our own professional colleagues and get it done. But our motto of Jnana Dasova, uh, our motto of Jnana Dasova, to enlighten our members in different topics. Every month we are trying at least one subtopic. To yes, we have to see. We cannot, because this after this Corona pandemic, our border should not be restricted. We should be, for knowledge, there is no barrier. Barrier. In that regard, Bangalore batch is conducting this Jnanada Sova web series. So it was an excellent presentation, Mr. Hari Prasad. The way you presented with the case laws and examples, and also the famous few ads, Colgate and Patanjali. It is making mind of the members resist when they are comparing, when they are guiding to their client It is very easy to remember. So on behalf of all the viewers, around nearly 400 viewers are actively participate for the today's session. And on behalf of managing committee members of Bangalore branch, I wholeheartedly thank you for your presentation. Thank you very much, Hari Prasad.
Thank you.
Members also make note that Advocate Hari Prasad, the uh, email ID and mobile number is displayed in the uh, screen. And also after this program, we'll definitely going to upload this PPT into our website. Members, with that note, as I mentioned, kindly make note that again our next week series will start on 23rd, 24th, and 25th, and 30th September. Next four sessions in the September month we have planned. The one is on RERA, one is on paceless assessment, and one is common errors in presentation and disclosure of private limited company. And 30th September we are having a session from Dr. B.V. Murali Krishna, recent technical developments in GST and portal, including EMIC. So, yes, we are already completing 2061st JNANA DASOHA live webcast program and moving towards to next series of the web series. On behalf of managing committee members of Bangalore Batch, I wholeheartedly thank all the viewers for your active participation. Once again, thank you, Advocate Hari Prasad, for spending his valuable time for sharing his knowledge to our members in the process of Janada. So, thank you, one and all. Happy weekend.
Thank you. Thank you. Thank you. Thank you, everyone. Thank you.